Good morning, Mr. Epstein.
Good morning, Chief Justice Marshall. May it please the Court. My name is Steve Epstein. I represent the appellants in this case. This is a matter of a discovery dispute that has arisen out of a district court order granting me an order to the Commonwealth to produce copies of citations issued by Trooper Patnode in the case involving others from the beginning of time in the sense of the beginning of the racial profiling data collection. And as argued in my brief under Chapter 90C, these documents are not only in the custody and control of the Worcester County District Attorney's Office to the extent complaints were filed, but these documents are in the custody and control of the trooper to the extent he retained copies. And in
Is there any evidence in the record of how long either the trooper or the state police superior keep these citation books?
There is none, Your Honor, but as far back as they would be able to get them, if they don't have them from the date it started, they would have them for a period of time, as it would take possibly years for the cases involving criminal complaints to reach a resolution, and those the district attorney himself would have, and it would certainly take many months for the disposal by the trooper. And I believe because it is for purposes initially 90C to prevent corrupt practices involving citations, I would believe that the state police department would keep them for at least 6 months to a year. But
Could you subpoena these documents from either the registry or the state police?
Should I have to subpoena them, Your Honor? This is a case of do not ask, do not tell,
No,
where
I
there
didn't
may
say
be
that. I said,
exculpatory.
Could you?
Could I? I would have to go to court and ask for permission to subpoena them, and then I would hope that the justice would grant it. But getting them from the Registry of Motor Vehicles, I don't know at all how long the Registry of Motor Vehicles, and if the Commonwealth argues that I should be getting them under the data collection statute, I'm not getting all of the data that would be available on a citation. I'm not getting date of birth. I'm not getting the location of the incident. I would then have to, and the reason why I took this first step in asking for the citations is that under the statute and Area C, and my sister did cite to the Executive Office of Public Safety's website concerning data collection, and on that website is the 2000 final report. And attached to that are tables that indicate that Area C, which is the barracks to which the officer in this case is located, that Area C does apparently have some racial disparities involving searches of motor vehicles.
Is there a preservation order in effect now? I mean, while this case is pending?
No, Your Honor, I have not obtained a preservation order.
Does the citation form show the racial or ethnic composition or data of the person stopped?
I believe it does, and I believe the citation is in the record appendix.
Okay, if it's there, we'll look at it.
And that it does include the date, time of the stop, the race, the age, the address, the nature of the crime. And that's the other thing I do not get from getting the data from the Registry of Motor Vehicles is I do not get the nature of the crime. And in this case, and one of the things that particularly stood out for me involved in this case is that the trooper neglected to note that these marijuana packages were in heat-sealed containers. And I serendipitously learned that only because I got a drug cert back before I argued this motion.
What's that got to do with racial profiling?
Well, I'm not sure I have a quote-unquote racial profiling case as Laura may have, in the sense that this vehicle was pulled over merely because they were black. What I have, I believe, is an officer who claims he smelt marijuana, doesn't tell us in his police report whether that's burnt marijuana or fresh marijuana, goes on to proceed to order a passenger out of the vehicle based upon alleged bloodshot eyes, asks them if they've been smoking marijuana, to which the client says, no, I have never smoked marijuana, and no evidence of smoked marijuana is found, and heat sealing is
But he does testify that he smells it, doesn't he?
We haven't had him under oath. He does state
But I
in the
mean,
police report, he
that's
says,
what I mean, yes.
but he says just marijuana. He smelt marijuana.
Yeah, doesn't he say there's like a forest of those little air freshener trees?
No,
inside
that's
the
not
car?
my case, Your that's not my case, Your Honor. There is no forest of air fresheners in this case. There is a stop on Route 84 around dark in the woods where the officer says he detected the odor of marijuana upon approaching the passenger side.
For again?
The alleged stop is for speeding, and which he then added on driving in the left lane, 89 4A, which is the other two cases that on the related issues before the court. So that he left that out, and then I have the decision of Justice Gardner where this officer in broad daylight failed in his direct examination apparently or on cross-examination to state that he recognized these people 2 cars over were dark-skinned Hispanic and a light-skinned Hispanic, and then Judge Gardner found him not credible on the tailgating charge, which was the basis of the stop.
How does that get you all of his prior citations? I mean, I don't understand how that relates to what you're asking.
Well, my first answer to that, Your Honor, is that that's not the issue that the Commonwealth raised in its petition before the single justice. The only issue the Commonwealth raised before the single justice is custody and control of these citations, not relevance.
Okay, fair enough.
But as to relevance, his citations will assist me in A, possibly making out a case as was made out in Laura, and B, will assist me in identifying particular cases for which I may want police reports, I may want decisions. I'm just at the early stages of discovery in this case.
But let's assume this is not a traffic stop. This is just an arrest, and you say, "Hey, I want to know all of the arrests this officer has ever made because I might be able to find in there maybe a case where a judge found him not credible, maybe a whole pattern of deceit and lying. Maybe I might find it." I mean, that's not usually the basis on which we would permit such a expedition.
That is not the case before you, but taking this as being a sidewalk stop, without additional information. But if I had additional information that other justices of the district court or other justices of the Superior Court had found this officer not credible at motions to suppress, I think trying to locate those cases is relevant to establishing that this officer lacks the necessary credibility to have gone beyond it.
And how can you take the fact that another judge found this officer not credible to affect this officer's credibility here? We say all the time that you can't use habit evidence.
No, I understand, Your Honor, that I can't use habit evidence, but it gives me information. It will assist me in preparing for my cross-examination of the officer, not concerning what he has done in the past, but seeing what other attorneys have been able to accomplish with this officer will provide me with necessary information, and I can only assume that I might be able to locate this.
Back a little bit. There's only one issue reported. Is that what you said?
My understanding is the only issue before this court raised in the Commonwealth's petition to this court
Was custody and control?
is whether this court should grant the Commonwealth's petition because the documents requested and ordered are not within the possession or control of the prosecution. That was the issue that they raised in their petition. In their brief, they start off with the identical issue as presented in the Betances case, prepared by the same assistant district attorney.
Normal appellate procedure is that we stick with the issue that's reported or raised, period.
That is my understanding, and that is what I focused on in my reply brief, that relevance isn't the issue in my case because it was not raised when the petition was filed with the Supreme Single Justice to raise the issue of whether the judge abused his discretion. Now, this is a judge who...
Don't we have a lot of cases on this issue of possession and control of what might be evidence that say the police and the prosecution are considered one person
Ye-
in terms of, conducting a prosecution, that they're not just like France and Germany, two separate countries?
No, the police officer, Trooper Patnode, involved is a part of the prosecution team in this case. And to go back to Justice Cowan's question concerning habit or prior acts, I am entitled to investigate this officer's experience in detecting the odor of marijuana, in estimating speed, both of which may be relevant to my success or non-success on a motion to suppress.
Certainly, that's correct, but you were positing his, whether another judge had found him credible or not.
No, but here I'm not
But
at...
you're talking about all kinds of possibilities for investigation once you get the materials that you can pursue. The question here is, if you're right, is possession and control, period.
Yes, and I have no doubt that Trooper, as I point out in my main brief, in every case Trooper Patnode in Worcester County issued a citation for a criminal complaint application or an arrest, the Worcester County District Attorney has copies of those citations in its very own files.
Even if they don't, they can be made to go get them.
That's what Judge Howarth ordered. Go get these for this gentleman.
And maybe they'll come back and say, after once a month we destroy them, and then that's a different story.
Then I go through the burden and the expense of subpoenaing from various other agencies.
So the issue here is very narrow.
Yes, the issue here is extremely narrow. Are the state police and the trooper involved part of the prosecution team in this case? And the answer has been, I don't know how long, but well back into the 20th century, that they are. This is not at all like Juanis, where they were looking for internal affairs information. So there's one other point I would, in addressing that, Justice Cowan, I am at the discovery phase. I am not at the trial phase. And this information will assist me at the motion to suppress, will assist me at, probably not at the trial phase, to the extent that the issues that I'm particularly concerned with, which is this officer's ability to detect the odor of marijuana in the evening in what is an extremely rural area where there are animals, rotting vegetation, other odors going on, and some of the other things that lead me to believe there's more going on here that meets the eye is he doesn't call for backup when he removes Mr. McDonald from the car and takes him back to his cruiser. Mr. McDonald, you'll see from the record appendix, is head and shoulders taller than I am. Head and shoulders taller than I am. He's a big man. And Mr. Thomas is left with the trooper's back turned to him as they go back to the car. This is not the general operating procedure that I would expect a trooper concerned and possibly in fear for his safety, which is possibly the only reason he could have possibly ordered Mr. McDonald out of the car in the first place. He could have waited for backup. Now, again, I say I'm very early in the discovery phase of this case, and therefore I don't know where it's going to go. I only, after the initial argument on this in December of the year 2006, did I obtain the turret tapes. And they're not part of the record, but I now have the turret tapes. And that indicates to me that there are other problems with what this officer had to say. And one final note, the Commonwealth did complain in its brief that I did not include my affidavit to the motion in the lower court. And I would note that the error is theirs because they did not include the affidavit in their petition to the single justice.
Thank you, Mr. Epstein.
Thank you.
Ms. King?
Good morning. May it please the Court. Michelle King, Assistant District Attorney. In terms of what's properly before the Court, I'd submit to the Court that the Commonwealth did make the argument in the lower court that relevancy was...
It's not in your petition.
We're here for the 211.3 petition, period.
Yes, I understand, Your Honor. Incorporated within that petition were the Commonwealth submissions below. There was a phone conference on this very issue between the parties on the 211-3. Raised within that phone conference was the issue of relevancy. So for defense counsel to say that that issue was never raised is disingenuous.
Could you wait, was the telephone conference before or after you filed your petition?
It was after the petition was
Well,
filed.
then
There was
don't we look to the petition? I mean, you can't, that's like saying, you know, I filed my brief and at oral argument I raised the issue. That doesn't really cut much mustard, does it?
well, certainly incorporated in the petition, Your Honor, were the underlying documents submitted.
Am I correct that the petition frames it, because I don't think it's in the record appendix, we can get it, of course, where this court should vacate the order of the district court requiring the documents not within the possession or control of the prosecution?
That sounds correct, Your Honor. I don't have it in front of me. I do believe that the question was phrased that way. Absolutely. I'm not denying that. But I would suggest to you that by the very fact that the Commonwealth included within its petition as part of the documents the underlying trial court submissions, that's included as part of the
The
petition.
phone conference wasn't with the single justice, was it?
Yes, it was,
It
Your
was.
Honor. And the issue was specifically talked about during the phone conference. But regardless of that, I think the relevancy issue is a small part of this.
Let me ask you this. Fact question. This motion was ruled on a year ago. Is there any doubt, is there any question that Trooper Patanud or the state police have access to these records?
There's nothing in the record that suggests that they do. I
No,
have
we
no
can't-
knowledge of that.
You don't know. After a year, you don't know. So you're not taking the position that, well, maybe they don't have these.
I have no knowledge, Your Honor, so I'm not
Could
taking
have
any
been
position.
destroyed for all we know.
Ms. King, let me ask you this. I understand your argument that some documents are in the registry of motor vehicles.
All of the documents under this statute are in the Registry of Motor Vehicles.
Some documents are in the registry of motor vehicles.
Okay.
Some documents are in the control of the police, correct?
I think, Your Honor, that it's
Some
a little...
documents are in the control of the police.
Some may be in the control of the police.
Why
I
has
don't
the
know.
Commonwealth, because it is perfectly clear that any documents in the possession of the police, for our purposes, are in the control of the Commonwealth, correct?
Well, generally, Your Honor, those documents are limited to the documents within the case that you're talking about. The defense counsel doesn't have a carte blanche opportunity to go into any
There was
police
an
record.
order, there was an order issued, correct?
Correct.
How does it possibly assist the administration of justice, for the prosecutor not to ask the question?
I'm not sure that the question wasn't asked, Your Honor. I wasn't the trial prosecutor. It's
Well, why
not in the
didn't
record,
you
and I'm
ask-
bound with what's on the
Why
record.
didn't you ask the trial prosecutor? I mean, what possible purpose is being served to spend years in battling over something where, in fact, the documents may not exist? Not because they haven't been destroyed. I mean, not because they've been willfully destroyed. I mean, if a simple telephone call would have said these documents don't exist, you go back into court and say, Your Honor, this is fine, file an affidavit.
But, Your Honor, it
not
places
the
the
but.
burden
What's the
on the
but?
Commonwealth in every single case to find out whether all of these documents for an extended
Only-
period of time, back to 2001, it places the burden on the Commonwealth to go back and check every single case where the defendant comes up.
A single telephone call. We don't know, for example, if these documents are routinely destroyed.
It's not one simple telephone call, Your Honor. You were talking about one case here, but you're talking about the thousands of other ones that come after. If the court rules that the Commonwealth, as a matter of automatic discovery, is required to produce any citation, it is.
Automatic discovery. I thought
That's
this
what the
was on
defendant claims it is. He's claiming that we needed to produce it as part of automatic discovery.
Well, that's not before us. The only question before us
Well, that's
is
how
is
he
the custody
requested it,
and
Your
control.
Honor. He requested it under automatic discovery. So basically, the trial judge
obtained-
ordered us to produce it as part of automatic discovery. So if if the court forces the Commonwealth in every single case to produce, as part of automatic discovery, citation reports back to the time of when the act was incepted, it's an enormous burden on the Commonwealth in each and every case.
Let me ask you
Don't
this.
know that.
Well,
There's no affidavit to that effect.
If we stick with the issue that's before us, or appears to be before us, we don't have to get into any of this stuff.
The
including what
issue
you
before us
just
is
argued.
whether or not it's under the possession and control of the Commonwealth.
And
The
the answer to
Commonwealth's
that is
position is,
yes.
as a matter of law, the keeper of the records of these particular citations is the Registry of Motor Vehicles.
Oh,
If you look at
no,
if you
that is
look
not-
at the act,
that is not the answer, because documents may be kept in more than one place. If the Commonwealth has said, did the Commonwealth argue below or here, they're not in the possession or custody of the Commonwealth because it was too burdensome to produce them,
no, the Commonwealth did not make that argument in the
then
trial
that
court. no.
argument is not here.
Has the, when you were before the, not you, but when someone in your office was before the trial judge, was there any suggestion made that a lawyer for the state police might be an appropriate person to come to court to talk about this?
Not that I'm aware of, Your Honor.
Because some counties do that, have a lawyer for the police department come talk about records that are being sought.
I think there was some discussion of that, but it never really came to fruition.
I forget, but is there anything in Chapter 90C, the statutes, that require how long these citations must be kept?
There is not, Your Honor, but I would suggest to you that the purpose of the 90C Section 2 is the no-fix statute.
know
So
that.
presumably, as soon as that case is over, the purpose of that
But, Ms.
statute
King,
has
you-
been
you-
effectuated and the citation could be destroyed.
Ms. King, the difficulty that I'm having here is that these are all arguments that could have been made. They're not before us. In other words,
That
we
argument
don't
was
know.
made, Your Honor.
The only question here is whether the documents are in the custody or control. And if they are, there's an order that has to be complied with. You may move for you may have had an opportunity to say it's too burdensome, we can't do it, they're not relevant, so on and so forth.
Again, Your Honor, it's the position of the Commonwealth that under the statute, under the Act rather, the defendant is seeking these very documents, and he says in his submissions in the trial court and here, he's seeking them under the Act. The Act is incredibly specific, Your Honor. The Registry of Motor Vehicles are to compile and collect the information under this Act.
And all of that is fine. I'm confused here. If the state police don't have them, that's one thing. They don't have them. Affidavit saying we don't have them. That's fine. Why are we talking about the Registry of Motor Vehicles?
Because under the Act that the defendant is actually seeking these documents under, it's clear who is the keeper of the records and who is to keep
Who
this
is he seeking
documentation.
the documents from?
He's seeking them from the Commonwealth
Right.
under a specific Act. Our position is that the Commonwealth is not the proper person to seek this through. He certainly has available to him a Rule 17 motion where he can go in and seek them directly from the
It's a
police
Rule
department.
14 motion, right? It's a
Correct.
Rule 14 motion. It's not
That's
automatic discovery. He's made a specific motion, and Rule 14 permits motions to be made for evidence not covered by the automatic discovery position.
If
He's
you
made a
look,
motion.
if you look at his submission, Your Honor, he clearly asks for the documents as part of automatic discovery. Clearly.
I'm sorry, is there another volume? Is the appendix supposed to be in your brief?
I didn't submit the appendix, Your Honor.
They
The-
call it
Separate volume. Separate
It's a
volume.
separate volume
Can I just
prepared
point
by
out
the
that-
defendant.
As I read that, he says, since the effective date, he's not asking them under that Act, he's saying, he's giving a time period, since the effective date.
I think
He
in another
asks
spot he
for-
says pursuant to the Act, Your Honor. He's seeking them pursuant to the Act.
He says, since
He's
the
never
effective-
made any claim that that's not why he's seeking them.
He says, since, I'm just reading the motion for discovery. And he's asking to order the Commonwealth to permit the defendant to inspect Massachusetts uniform citation issued by a particular trooper and the audit sheets related to there since the effective date. He's not saying he's moving pursuant to that Act. And if the Commonwealth, if the state police have those documents, they are covered. Unless the Commonwealth, more than one agency may have records. One agency may be out of the control of the prosecutor.
Again, Your Honor, I think possession and control goes to a particular case. The defendant doesn't have the right to go in and under a fishing expedition, search through
That's
any file or
relevancy.
any document that the police hold. It has to be specific to a case. And here he's gone in and asked for citations that have absolutely no relation to the case at hand, hoping
It's-
on a
you're
hope,
back
a
on
whim,
re-
a guess to
You're
find
back on
some
relevant-
information.
You're back on relevancy, which isn't before us.
No, I don't think so. I think we're talking about possession and control. I'm talking about he doesn't have a right of
That's
discovery for
relevance.
any document that's ever in the possession of a police department
That's
just because
relevance.
it's a police officer.
That's relevance.
Well, anyway.
If there are no further questions.
Thank you, Ms. King.